Hello, my name is Paul Contino, a former patent examiner with the United States Patent and Trademark Office. At this month's Business Blend, I will be demystifying the patent process. I will be giving an overview of the patent process, of lessons I have learned over the years, and various insights, including pitfalls inventors should be aware of. So join us for an informal dive into patents geared for anyone interested in learning more about the patent process. Good morning. My name is Paul Contino, and today I'll be presenting a bit about demystifying the patent process. I used to be a patent examiner at the US Patent and Trademark Office for a long time, and it's just something that I kind of wanted to share a little bit of what my experience was. First, just like Adam, I would like to thank Pullman Marketing so much for this opportunity and for the Business Blend. It's been really fantastic to be able to be a part of them as well as Umpqua Bank for the space. And the mentorship that I have received from Washington SBDC, specifically Aziz here. He's been a wonderful wealth of information. So a little bit about me. That's me. I went to Penn State University. I got a degree in electrical engineering. And then I worked at the US Patent and Trademark Office as a patent examiner in computer systems, specifically in an area called computer reliability and fault tolerance. So basically anything that had to do making sure computers run properly, making sure that backup systems are in place, anything that if you incur an error, that you can recover from that. So that was my specific area. Did that for about 12 years. And then decided to kind of go out on my own for various reasons, but I wanted to get a little bit more, and more in touch with what the inventors are doing. And so I formed a patent consultancy earlier this year, and that's what I've been doing ever since. So why this presentation? So I kind of want to give back all that I've learned over those years of what I have learned. As Adam had mentioned, if you go to the USPTO website, which I believe is a wealth of information, it's really important. They have everything you need. It's just there's a lot of information and it's very hard to decipher. So I kind of want to be that person that can help get at least a general understanding, informal understanding of what's involved with patents, that base understanding. Also, I've gotten encouragement from Aziz, for example, as well as there's a national organization called SCORE, which they do have a Washington chapter, and it's very similar to SBDC's. Same type of thing where they have mentees, mentors there, but they had also mentioned to me that there's just a lack of information from actual individuals, other than going to blogs or reading articles or the USPTO website. Also, it's very important for me to let you know what this presentation is. So it's a bit about demystifying that patent process. You'll learn a little bit about what I did from behind the scenes, working at the USPTO, USPTO being the United States Patent and Trademark Office. Something that I feel is probably the most important aspect of when you're considering getting a patent is what we call prior art search. And that's just doing research to see if there is a patent already out there, or somebody's already created what you would like to get a patent on. Some general patent considerations based on lessons that I've learned over the years. Also very important, I am not a lawyer. I cannot offer legal advice. So there is a lot of law that's involved in patents. It's kind of the granting of patents is based on law because it basically has to do with protecting your idea, preventing others from making, using, selling what it is that you've created. But I'm not that legal professional. Also, this is not an in-depth look at general intellectual property, such as trademarks and trade names, copyrights. Aziz is a good person to talk to about it. I believe he has some videos on that too. All right, so I'm going to introduce, well, not introduce really, there are three very famous people that you should be well aware of when their pictures come up that have a hand in patents. George Washington, exactly, our first president here. He signed the actual first patent that was ever granted in, I think, 1790. It was a patent for for potash, which has to do with, I believe it's some type of fertilization for agricultural systems. But he was the guy that signed that first patent. And this guy, Thomas Jefferson, he was the first head of the first patent office at that time as well. And then this last guy, Albert Einstein, no patents that I'm aware of. He's got none. Really smart guy, very theoretical, but he was a patent examiner for a long time for the Swiss Patent Office. For the moment, right here, there's one patent office. If you want a patent, if you want a trademark for that as well, there's only one place you can do it in the US. It's in Alexandria, Virginia. It used to be in Washington, DC. Then they expanded a bit and had to move to Alexandria because of the number of people that they were employing. But there's only one place in the US. If you want a patent, you have to go there. You have to go through the USPTO. However, maybe about 15 years ago, they decided to offer branch offices in Detroit, Dallas, Denver, and San Jose. And part of this was to attract more higher caliber employees, because you had some really intelligent engineers and people that worked out on the West Coast, and to try to have them come all the way out to DC, where they might be in like Silicon Valley, it's kind of a hard sell for them. So they decided to expand a little bit. Also, they have these satellite offices, which I'm not, or these called patent trademark resource centers. I'm not too familiar with them. I'd have to guess it's probably just a dedicated place where they have computers set up for searches. You might have some people there that can help you with that. Looks like there's one up in Seattle. I'm going to guess it's either at the main public library in Seattle, or it's at the University of Washington there. So they are scattered out a little bit now. But the main thing is there's only one place to get a patent. You have to go through USPTO. So what exactly is a patent? Again, a lot of this is based on law. I'm not going to read the whole thing, but the main thing is that if you, the inventor, come up with an idea, it gives you the right legally to exclude others from making, using, offering for sale, or selling what it is that you've come up with. Something that it does not do, it doesn't give you that right to make, use, offer for sale yourself so much as it just stops others from doing that. It's kind of up to you whether, once you get your patent, if you're going to go out and market and try to sell your particular invention or idea. Also, what can be patented? So legally, a process, a machine, article of manufacture, or composition of matter. There are three main types of patents. There's a utility patent, something that has utility. You think of something that's more specific, like physical, I guess, like anything. This can be patented, the lights, the clicker, cameras, all that. Plants as well can be patented. Some type of like genetic engineering, you can patent that particular type of plant. Also designs can be patented based on your physical, with the physical description of what it is that you have created looks like. Drugs can be patented. Certain business and financial methods and software can be patented, although it's kind of contentious because it's not something very tangible. It's rather abstract. There's a lot of litigation with that. Certain things cannot be, anything that's like natural cannot be patented, that occurs naturally. Mental processes cannot be patented. You can't process the way that you think about things. And cancer drugs as well cannot be patented or cures for cancer, I should say. At least not now, because we have not found a cure. But that's something very specific that the USPTO mentions. So, what does a patent look like? Well, the first patent looked like this. Very handwritten, on script. You have Washington's signature there. You have the inventor down here. You have an official seal. So that's what it used to look like back in 1790. However, this is what a patent looks like today, which is obviously got a lot more information on it, a lot more formal. There's a barcode, easy to scan in. Everything's electronic now. It's a United States patent. There are patents granted in other countries. This is the inventor. Et al. Means that there are multiple inventors involved. There's a patent number that's given. I think we're probably up to 12 million-ish, maybe. It's been a while since I looked. And the date that the patent was granted. You also have a title of the patent. You have applicant, inventors, and assignee. So applicant is the entity or the person that is applying for this particular patent, which is, in this case, Google. Google has people that work for the company. The inventors that came up with this particular idea are these right here, they're listed. And then if a patent's granted, there's an assignation to who gets the rights to the patent. In this case, as with most companies that have employees working for them, Google gets they get the rights signed over to them. There's some legal verbiage there. Let's see. Then you have actual a publication or an application number. So that's the Series 15, what that first number is based on the year that it's filed in. When it was actually filed, which is very important. That filing date is one of the most important things with patents as well. It's the first person to file, first entity to file is the one that gets the rights to the patent if it's granted. Also, these, when patents have been applied for, sometimes they publish the description of what could be patented in the future when it's pending. And that just kind of discloses what has been filed for patent, even though it may not be granted. Let's see, sometimes there are prior applications that have been filed, provisional as well. So there's two types of patents that a lot of people will consider filing as one's a provisional, one's non-provisional. Provisional is kind of just like a placeholder. When you think you want to file for a formal patent, but you still might be developing the idea, you're granted about a year before you can make that decision. If you come to the decision, hey, this is a really good idea, I want to do my formal application, you file what's called non-provisional. A lot of terminology, I know.
Is there a requirement that the company that files it have to use it in one of their products? And if so, in Google's case, how are they using this in their products?
If they get a patent, it's up to them whether they actually want to use this or not. But basically, so this, looking at the title, basically what they're doing, let's see, monitoring, controlling a backup power supply using temperature-controlled batteries. So they they use this with, I guess, whatever they use for batteries that are monitored based on temperature in case they get too hot. So I'm going to imagine Google probably uses this either maybe in their cell phones, but probably in some type of like server systems, I would expect. So this is probably something that we'll never see, but that's really important, like a mechanism behind the scenes of like the Google Cloud and all that stuff, right? It's up to them if they actually want to use it.
So you don't have to necessarily offer the product commercially?
Sure. But for example, so Google, one of their competitors is Amazon, and they have AWS, which is like this huge server system as well. So if Google comes up with this idea, technically Amazon can't create it and sell it, should not be using it. They would say, hey, Google's already done this, which we need something like this. They would buy it from Google because Google has a patent. Does that answer your question?
Yes.
Okay, but the thing is, you can patent it. You don't have to do anything with the idea afterwards. It's up to you whether you want to market it.
Sometimes you're engineering, you're designing something, and it's a group of people, and you're working on it, and then you realize this is an invention. This is something that has value beyond just what we're doing here. Somebody else would be interested in this. And a company like Google is going to have a whole stable of patent attorneys and a whole department to file patents. And so you shove it over to them and say, hey, get this rolling. And so there's a year between, the provisional is, it takes time to get that going, but there's people dedicated to it. And then they own it, and then you can sell the patent. It becomes a whole other part of the business now that you have all this intellectual property you can sell off.
Yeah, and companies like Google have, like you said, lots of money, lots of lawyers, so might as well do it if they come up with an idea, just in case, right? Also, something else that you mentioned really important. So they have this date, August 21st, 2017. When was the patent actually granted? 2020. So which month was it? May. So that was a good, 2.5 years later? So that's pretty normal. It takes a while. It's a process. A couple other things. So there are classification areas, and this is both for us that work on behind the scenes to know a specific area. I want to make sure I'm going to the area that deals with computers and batteries and maybe like temperature monitoring, all right? Also, we work with other patent offices across the world. So there's what they call, so we have US classifications just for here. Then there's international classifications as well, particular areas of search.
Would you typically be working on several patents at one time? You're not just going to be exclusively working on this for 2 years. Correct. You're working on several at a time.
Yeah. So basically it's a pipeline. It's kind of like an inbox, outbox type thing. And so when I was finally able to get to this particular application, I review it, do research, determine if there's anything that's similar to it. And then I write a report and send that report back out to, in this case, probably the lawyer. You notice there's attorneys that are there too. So I send, they're the representative attorneys for Google. So I send them my report. Say, hey, this is what I found, whether or not I feel that it's patentable at the moment. And then once that's sent out to them, then I work on something else. And what normally happens, there are certain time frames. They have, from what I can remember, there's about 3 months where they have to respond to my particular response. They can do up to 6 months if they pay extra fees. I think they can go up to a year if they pay extra fees. A lot of, just keep paying money, right? It's government. So one thing really, so, it's something I always got a lot of kickback on was like, oh, you work for the government. You're like, one of those people and paying tax dollars. And the USPTO, we bring in money. It's all private. We don't get paid by tax. We don't get paid by the taxpayers, technically. We bring in all this money, like Google foots the bill for all this. And all the money that we get, which is an incredible amount of money, goes to the government and they do whatever they want with it. But I was like, I'm the one helping you guys out, I'm like saving your taxes there. Yeah, so a lot of information there. Going back up here real quick. So there's some references here. Some are US patent documents, some are foreign patent documents, some are other publications like on a website or a journal publication. Could be a video, for example. Anything that there's a duty for whoever applies for a patent to disclose what they already are aware of, as well as whatever I find in my research, I want to put on this patent because I want to prove, hey, they deserve this patent because the best thing that we could find that's similar to it, but not exactly this, to help support their claim to something novel, it's here as well. So you can do your research, you can see what was kind of similar. And then the primary examiner, in this case, this was me, as well as the attorneys that work on it. So we're the main people that actually get this to become a patent. Also on the front page, you're going to have a brief summary, an abstract of what it is this invention is, and then a drawing that's representative of what the particular invention is. People don't send in their ideas anymore. Basically, what you have to do is you just have to have a really detailed description of what it is that you've invented that can prove that, one, you possess the idea, and two, that anybody can make the idea. As well as drawings to illustrate what it is that you've come up with. And you send in a document. It's done electronically today for the most part. But yeah, nobody would ever send us in anything interesting, unfortunately. So yeah, that's what patents look like today.
Well, is there a process for provisional other than people submit it and pay for it? Do you do any kind of review? Or?
No, because provisional, so when you send in something that's provisional, it's basically kind of like getting your foot in the door for a patent. You have a year. You have a year to make a determination. Do you actually really want to go ahead and get this patent, or is there some information missing that you need to incorporate before you have like your fully, your full description of what it is? Maybe you're in your beta testing and you know it's going to be done in 6 months. Well, let's get that initial date. And that's not published. It's not, you have no fear that somebody could take your idea within this year, but you're basically granted a year to make that determination. And if within that year you say, hey, I want to go for the patent, then it gets informally, then I would see it. And if not, it just goes, we call it abandoned, and it just kind of disappears. So the patent office used to be the first person to invent something or to get a patent on something was they get rights to the date of the patenting. But There are reasons why they changed it to the first person to file. So provisional, it just kind of gives you that lead time where like you're almost done everything, but you want to establish that early date of protection as early as possible based on at least your idea.
If you have an idea, if person A had an idea, did a provisional patent, and then a month later, a bigger entity came and put a real patent application for the same idea, the provisional patent would still count as having the earlier.
If you decide, yes, it would. Yeah. In short, it would. So long as you decide to actually go to full that non-provisional, yeah. And yeah, exactly. Yeah. But a lot of times, like people just have this great idea and they have almost everything there, and they want that date. But they might be missing one thing, like maybe it's just like a lever on like a camera, for example. And so they haven't completely figured out how they're going to make that lever, but the rest of the camera and the idea is there. So in 3 months, they come up with that lever, then they incorporate that, and then they can go file for their full one. You had a question?
Does the life of the patent start from your provisional patent date? Or
Yes. From the provisional date. So here's the patent process. Pretty straightforward, right? You get ready to apply, you file your application. It goes through what they call prosecution, which is examiner's review, and then the attorneys or the inventors back and forth. Then you receive your patent, or you don't receive your patent. And then if you want to make sure, I think you get up to 20 years. Every X amount of years, you get to pay the government again to keep that protection on your idea up to 20 years. There's a link here. I don't know if this will be shared or maybe like the slides to this might be shared. Okay, great, they will be. So this will be shared. I have links all over for different, what I feel is important information. Always to the USPTO. That's always the place you want to go. A lot of information, but it's the one authoritative place.
So the longest queue might be the application prosecution.
Yeah, so once you filed something, it could take a year and a half, depending on the area of what we call technology. It could take a year to year and a half. When I was there, we had a backlog of about a year and a half. If you would send something in, it would take a year and a half before I even saw it. For example, today, AI is huge. So they might have like a 2-year backlog because everybody's filing applications for AI. There's only a certain amount of people that can look at it. Whereas maybe projectors aren't really in high demand anymore. But people are still coming up with ideas, and they might be looked at in like 3 months. So it really depends on the area. But yeah, there's a lot. The first part is waiting until somebody gets to look at it, and the second part is that back and forth with attorneys. Because most of the time, you file something, somebody like an examiner looks at it, there's formalities that are involved, you have to look at, you do research, but then there might be something missing or might be close but not just right. You might have to clarify certain things. And so in that report that's sent back to the inventor or the attorney, they would revise it on their time, then they send it back to us, and that can also take months or years in certain cases. Yeah, so this is kind of like the meat and body of time anyway. So one of the things I say is just be patient. You gotta be patient. Yeah, so who can file a patent? Anybody can file for a patent. Individuals like yourself, small businesses, large corporations, universities do a lot, like WSU here, with their research. Again, everything that you need to file for a patent, all the required documents, you need to have certain description and drawings, it has to be formatted a certain way. Yes, we have a drawing expert over here that knows like you need certain things anyway, like it has to be certain specifications, right? Certain fees. There's just like a lot that's involved. It can be overwhelming if you just go to the USPTO website, but just kind of take your time, everything's there. Basically, so the first step is just making sure you know how to describe your invention, and you get it all written down and ready to send in. The second is, so how do you file it? Well, basically you go to the USPTO website. There you can create a login, and then you upload as docx, I think is the format they're using, but you basically have all your documents in electronic form and you send it in electronically. You can do it by hand, send in by mail. It's an extra $200 to $400 if you want to do that because of extra processing. We touched on this provisional versus non-provisional. You have to make that determination. And then, well, okay, so can anybody tell me what patent pending means to them? Because you see it everywhere, right? So provisional could technically means patent pending. Basically, once you have that patent application, be it a provisional or a non-provisional, your patent is waiting to be looked at. It's pending. So from my perspective, it just means, it's like a marketing term. You see patent pending, yeah, right? Okay. So yeah, that's all that it is. It just means that you've applied for a patent. It doesn't mean you're going to get one, but that's it. But you see it everywhere. So that's what patent pending is.
There's a rough idea of the percentage of patents that are granted. I'm sure it changes whether it's technology or other ideas, but is it roughly a 50-50 shot, or what do you think?
Yeah, so, well, in my particular area, I want to say I probably pushed through 70 to 80% that eventually got patented. But I would say an initial, so if something comes in and it's not proper or there has to be further discussion, we send out what we call a rejection. It doesn't necessarily mean it's like a final rejection, but it's an initial, hey, something's wrong with this or something has to be revised, clarification, whatnot. I would say probably 80%, 90% of what I would first time applied gets an initial rejection for various reasons. And then they come back, they make what they call amendments, changes to it for further clarification or stronger support. And then, like I said, I was pretty tough, so it took a little while. There might be a couple cycles, but it's because I want to make sure you have as defined as possible what it is that you're trying to get a patent on. But eventually it comes out in my area 70 to 80%. A lot of it just really depends. Yeah, it depends on the area.
Is there number of times that you would iterate with the lawyer? Yes. So do you have a limit on how many times you go back?
Yeah, technically, lawyers are granted what we call an interview, basically a discussion. You're granted one interview per correspondence. So they send something in. If I feel like it's worth calling them to have a discussion to get some formality out of the way, I'll do it. Otherwise, what I will do is I'll send a report back to them. And then if they disagree or they need some further clarification from my end, they're allowed one phone call to us. Because otherwise it just gets way too much. Plus attorneys are expensive, and so they're getting paid for their time. So again, there's different reasons why, but normally just one discussion. All right, so you've got your application in, you've paid your fees. What happens during prosecution? All right, so there's a lot of stuff. Like I said, you look for the formalities, fees, we have administration that processes all the fees, that scans certain documents, that classifies where these particular inventions should be put at, basically into like a technology center filing system, as I mentioned. So there's different areas. So I was in a particular area that dealt with computers. It's like they have different silos, I guess you could think of. And then there's like biological areas and there's toy areas, right? So they have a different area for everything. So once those applications have come in, they're reviewed by an examiner who reviews for further formalities. They do a search to see what could be out there. And then they will generate a report, send it back to the applicant or the attorney. Pro se, I'll get to in a moment. And then the attorney reviews, responds if necessary, and then you either eventually get a patent. So you get what we call allowance for a patent, a rejection, sorry, you don't get a patent. Abandonment, they just let it go for whatever reason. They know they're not going to get a patent or they ran out of money, for example. Restrictions and continuations are certain other things. Sometimes people file patents and they include multiple inventions, and so you have to restrict it to one particular invention. Continuations, say you filed an application and a couple years later you came up with this great addition to that particular invention that you had, so you kind of get support from your initial date that you filed, but you want to continue it for new material that you want to get an invention on. So there's a lot of stuff that goes on here. But this is kind of like, you just got to wait this out. And then, okay, so yeah, you get her patent, great. You get that piece of paper like you saw earlier that gives you that proof to exclude others. If there's a disagreement, like say that I've reviewed and I found some evidence, hey, you don't get a patent, but then some company says, we think that we should get a patent, back and forth, there's arbitration. Attorneys can appeal, and it goes to a higher court to make that determination. I provide my evidence, companies provide theirs, and then somebody else makes that determination. Patents are published. Why are patents published?
The prior art, so it's known what the prior art is.
So it is, so it's known. So people know what's already been done. Also, the main reason for that was to foster innovation. So not only just to see what you can't do, but hey, this is the greatest thing that's out there, so what can I do to make it better? So now I'm given the tools to make something that's already great. What can I do that fosters innovation? And as I mentioned before, to get up to your 20 years, you pay every so many years, pay the government some money, and then you get your patent. All right, so why is it important for me? So what for you guys, right? For small businesses, maybe you have no interest in ever getting a patent. You're not an inventor. You're not thinking about, there's a lot of information here. It's way too much. It's just totally, I'm not interested. Well, once upon a time, there was a speech therapist who I met a couple months ago, and she reached out to me because, she works with kids, and she was always trying to find a way, how do I get kids more involved and engaged in order to make sure that they are able to speak more clearly, or whatever it is that, they're frustrated with the particular, not being able to express themselves. And so she thought, well, animals are great. Kids like animals, and colors are great. And so she was like, what can I do to make this more engaging? And she came up with this idea. She got a 3D printer, and she created a dog head and with a big mouth. And she's got these like little bones that have different, vocals or something assigned to it. And every time that one of her clients does something well, they get to feed the dog. And they loved it. And she said that they responded really well to this, and that they were learning a lot better. And she's like, so she did some research. She saw nobody else had done this. And she thought, maybe I could get a patent on this. Maybe this is something I could eventually sell. Or maybe it's something that I would like to share with other colleagues across the country in the speech therapy world. Or you know what? There are like the play and learn companies might pick up on this, for example. And so if she gets a patent on this, she's got those rights to not just exclude others, but she could license it, right? Or she could sell this idea. And not because she wanted to make a lot of money, but because she came up with this great idea and thought, hey, the next logical step for me is possibly getting a patent. So you never know. I mean, she never thought about it. And now she's got another one that's coming out. She's got cats now. So she's got this company, Chomper Champs, now, and she's got these particular designs. She's determining whether or not she wants to patent, and so you never know, right? So I figured this is another thing too. I just kind of want to give a general overview of, okay, it is attainable, and you never know when you might come across something. Hey, I have an idea, and at least you know how to get started. USPTO website, do a search, and then from there. So she's been a real joy to talk to about this. How are we doing? Any questions at the moment? I mean, you guys have actually been good so far.
Are there people who do business models on reviving abandoned patents?
Business models?
Yeah, because if there's an abandoned patent, can just anyone go and try and take that on and refile for it?
So, no. Okay, so anything that's published out there prior to when you file for a patent prevents you from getting a patent. So if it's published but was abandoned, even though there's not a patent granted, you're not going to be able to get it because it's already proved that somebody else had that idea.
Right, but if the person is passed away or had other things, does that just mean that technology can never re-exist?
No, it can exist. Anybody can make it. You can make it. You can profit off it. You can't get a patent on it. That's all. So at that point, from my perspective, again, Aziz, because he's actually been through this process a bit himself, and he's a little bit more business aware. and correct me if I'm wrong, but my understanding is, okay, so it's out there, it's not patented, you can't get a patent because the documentation is out there that somebody else had the idea, but you can develop it yourself and sell it yourself because nobody owns the rights to it.
Isn't a lot of the application process the examiner finds that there's a prior art that's pretty similar to your application and you get the rejection, but then you spend some time and you tweak your invention a bit to the point where it does become a...
You don't change your invention, you clarify the words. Because I don't think we have time, but there's a section called the claims section. So the patent has a front page, like you saw, a very detailed description of everything that's involved in an area called claims. And that claims area is basically your legal rights to it. And that's very specific. It does include all that stuff. So the best thing I can think of is, say Apple comes out with this great idea of unlocking a phone using your face, okay? So what they're gonna do is they want a patent on this idea of unlocking your phone based on some bio reading or whatever. But they want the broadest possible so they can market it broadest possible. So they'll send in this great detailed description of how their Face ID and everything works, but then in the claim language, they'll say a communication device with an ability to unlock the phone using biometrics. Well, so all I would have to do is send them a picture of like a Google phone and say, well, they have the finger swipe or whatever. So I send it back to them with the description of the Google phone. They say, all right, you got us. We have to put the actual Face ID in. So then they move that to the claim area, which makes it more narrow. So it kind of constricts them to what they can make money on. So they send it back and say, okay, communication device with a way to unlock your phone using biometrics, wherein biometrics include face identification. Do research, nobody's done that, great, you get a patent. So that happens a lot, yeah.
But it's gotta be like, you gotta say how you're gonna do it. I can't go and say, put an application in for a flying skateboard.
Exactly, like Marty McFly there. He's got his hoverboard and everything. So you got to prove to me this can actually be done. So that's another thing too. And if you can't prove it in your description that this is something that could really happen, I'm not going to give you a patent, regardless of whether it's out there or not. Hoverboard right now, I'm not going to give you a patent unless you can prove there's some type of like anti-gravity. I don't think we're there yet. A couple quick things. So pro se inventor, if you decide to go off on your own to file a patent all by yourself, you're considered pro se. And what that does is it saves you a lot. So there's benefits and drawbacks. Saves you a lot of money. You don't have to pay for lawyers. It's your time. So you write exactly what you want in there. Drawbacks are there's a lot of legal lees involved. So you might miss certain things. You might not write things like you might not be able to word your claim language in the best possible way to get a patent. Fortunately, the USPTO does have a particular program to help individual inventors. There's a website there's a hotline you can call and they can help you with certain things. If you do decide to hire an attorney, which for the most part I recommend at least consulting with an attorney, very important. They have a list of all the registered attorneys in the US, so you can go to their website as well. So one of those main benefits is money, right? So there are fees obviously involved. If you're an individual or small business making under X amount per year, you're considered a micro entity. It only costs you $64 to apply for a patent. There are extra fees involved, but that's an initial $64. If you're a medium-sized business, $128. If you're somebody like Google, you get $320 for your initial fee. The fee schedule looks something like this. So all the different possible reasons for sending in different documents and extensions, etc. And you'll notice some of those numbers get really big really fast. If you file all the exact documentation you need, if there are no mistakes, if I cannot prove that there's something else out there and you get a patent right off the bat, but the chances of that actually happening, doing it by yourself, are pretty slim. Not that it doesn't happen, but and if you do that, you could probably get a patent for within $5,000, around $5,000. I would say 10 to 20 is probably normal if you use an attorney. But again, because attorneys cost money, they're lawyers as well as you're trying to get something you're going to market and make money off of. Should you get a patent? Aziz is a great person to talk to about it. There are different schools of thought. Depends on your end goal, your needs. It offers you certain protection. You can license it, you can sell it. However, if somebody comes after you for infringement, you have to defend yourself in court. That can be expensive. About 5 minutes, okay. Some people just like to have like a nice on your wall. It's like framed. You get a medallion or something. Looks nice, just for pride. Hey, I've got a patent. You know.
So if you hold a patent, you could still possibly be sued for infringement.
Oh yeah, and there are individuals and companies that specifically do that. Patent trolls, where they look at all the patents that are out there and they determine whether or not on their own if they should actually get a patent, if they should have gotten a patent, what's similar, and then there's can be companies that, and sometimes we're only human. We do the best that we can to see what's out there, and sometimes we just don't have all the time in the world to look at everything that's out there. And so I don't know if you're like BlackBerry got sued, I think, for their particular platform, which is huge, right? Because there's a lot, again, legal wording, and it happens. Okay, so, and then are you ready to file a patent? Make a determination, do you actually need a patent? Do you really need one? Make sure you can really describe it clearly, because that description is really, really important if you send it in. Determine how much money you have, if you can do it yourself. Time as well, if you want to hire a lawyer, if you can defend yourself in court. I recommend, carrying out what we call a prior art search. Prior art is anything that has been published before the filing, any product, any advertisement, any journal article, any magazine article, video, patent, anything of that is considered prior art that can prevent you from getting a patent. So that's something anybody can do on their own. Google has a good patent search. The USPTO has a great patent search with certain caveats. Determine, again, if you want to do it yourself, hire an attorney. Understand the process, kind of gave you an overview with that. Again, everything's on the USPTO website. But the more that you know going into it, the better you'll be able to make an educated decision. Should you file a patent? Should you do it by yourself? What certain expectations are? And be patient. Okay, so I'm not going to go into this because of time, but basically, prior art searching is really important. The USPTO has a step-by-step guide online. They have 6 different ways of kind of approaching this step-by-step, and then they have a certain interface. So this will be shared later. You can go through. Something really important here, you can do it yourself by going to Google Patents and Scholar to see what's out there. Local libraries are great. Here, not so much. Spokane and out in Seattle have business libraries with individuals there that can really help you at least get started. Or you can hire somebody. My particular area of specialty is searching. Searching is what I feel most comfortable doing. But otherwise, you can hire an attorney. Attorneys most of the time outsource their searching, but they understand all the process and everything involved. Some certain special considerations, non-obviousness. I'm not going to go into AI searching. Be careful with AI. It's getting really good, but it still may produce incorrect results called hallucinations. Also, it might be taking your data. So if you come up with this great idea and you don't want anybody else to know about it, you probably don't want to use AI. Just be careful. Again, patent attorneys, agents, if you do decide to get somebody, I think it's really important just feel them out, if you're comfortable with them or not. If you're comfortable with them, if they are going to advocate for you, and if they have a particular background that aligns with your idea. If you want to do toys, hire an attorney that's dealt with toys before. If you want to do computers, hire somebody that's dealt with computers and an engineer. Examiners as well, they have their own personality and agenda. Pro se, we went over that. And then resources. Thanks very much.